Amit Elazari. She's a doctoral candidate at Berkeley Law, and she's going to give a talk today. Here she is.
Okay.
Yeah, you're good.
Can you hear me, guys? Well, I'm very excited. Let me just put this here so you can hear me even better. Because this is my first visit to Hacker Summer Camp, and I'm honored to present here. I had a script and everything, but you're getting like a kind of a raw, version of it because I decided to go without my Kindle and without my notes, but I think it's better. So I'm a doctoral law candidate at Berkeley Law and a CTSP fellow at Berkeley School of Information. And I know it's pretty tough to be the last one, okay, last speaker of today, but think of this as like a legal appetizer for your parties tonight, okay? So first of all, a little bit of a disclaimer. While I am a lawyer, and this is a terms of use talk, this is by no means a legal advice kind of talk, and I'm not admitted to practice law here in California. Okay? So without further ado, they tell us that the bag economy is exploding, right? Millions paid around different platforms, hundreds of thousands of hackers. Everybody is into this new best practice in information security. But who dictates the rules of this developing industry? Well, I did the first novel research of legal bag bounties. I went and read all the terms of the platforms, of background, of HackerOne platform terms, and to Google and Facebook terms to see if there really are the kind of safe harbor they're supposed to be. So the motivation for this is also inspired by recent development in the Computer Fraud and Abuse Act and the DMCA Act, the two most important anti-hacking laws, okay, that made the contractual terms the focal point of the legal analysis of whether the hacker is indeed in legal risk for doing penetration testing and bag hunting. Okay? So now as we see a growing number of bag bounties, we really need to understand, are these truly safe harbors as they claim to be? So what I found out is a lot of programs are not clearly constructing the safe harbor they're supposed to be. We see kind of language that hackers need to comply with all laws, domestically and internationally. Hackers are not allowed to reverse engineering and doing, tinkering and basic cybersecurity techniques they need to do in order to do their job. And we also see very paradoxical terms just clearly stating that no license or permission is given to any penetration or attack against any of the systems. Now, this is from Alibaba. And this is across platforms. I did more than 20 legal bounties research, sample. And this is consistent. This is not, related to any particular platform, whether HackerOne or background. We see problems at Facebook terms or also in, independent bag bounty programs. It's just all over the place, and I think that no one is really giving attention to this problem. So I'm here today to speak with you, the direct audience of hunters who are influenced by this, and to start a conversation about the problems you see. So what I also saw is a lot of, kind of attention and a lot of emphasis on the technical scope of the program. So just as an experiment here, who here is a hunter, okay, and ever read or pay attention to the legal terms? Right? No one reads them except poor me, okay? So we really need to think about that because, as you will see right now, there are legal implications. I know that no one is prosecuting bug hunters, but there is no reasons that the terms we see now will create a situation where hackers are basically at a de facto default breach for doing their job. So what is most important is this is not new to us. We in the academy, we've been speaking about these issues for years. There is an article from 2014 talking about this issue, although not doing a survey or legal bug bounty terms, but saying, pay attention to the way you craft the terms of the bug bounty. But the message hasn't synced in the community, okay? Because we need you to take action and vote in your legs, or rather fingers, not participating in, in programs that are problematic legally, okay? Making sure you collaborate with the platforms that will negotiate on your behalf with the companies to ensure you have, that your legal risks are mitigated. So hackers' actions speak louder than scholars' words. We need your help. So let's begin. I'm going to do a very short preview. I have a full article. I have a lot of knowledge about this. If you want to talk, let's do that. I'm going to do that like really short. So there are two, let's say, three important points you need to know. First of all, the two main anti-hacking laws in the United States, the DMCA and the Computer Fraud and Abuse Act, they have an extraterritorial reach. So even if you're from India or from somewhere else, and I know there are the hunters, community is well diverse, and I appreciate that, you need to be aware that, United States law might apply to you. But these two, main anti-hacking laws, in the end, after years and years, what it comes down to is consent and authorization. Right now, the combination of these three laws, one, the DMCA, okay, which prohibits circumvention of systems, okay, that protect copyrighted work, code, in this situation, and the CFAA, which restricts and criminalizes unauthorized access, okay, to protected computers. In the end, both of them, with the new DMCA exception with security research. So the Copyright Office, the legislator, they understand that we need to facilitate security research. And they say, okay, that if it's a consumer-oriented product and good faith security research under certain terms, it's no problem with copyright law. But what both of these laws require is consent. Both of these laws require the contract will allow you to do that. So even if copyright law gives you a fair use right to reverse engineer, even the DMCA says you're allowed to do, information security research, but the platform, the hacker platforms, or the company, in their end-user license agreement, which they sometimes subject hackers to, say you're not allowed to reverse engineer, you're not allowed to penetrate the systems, they take back these protections the law gives you. So in the end, the contract language is really important. And I don't know why people are not paying attention. So it's kind of a system. Even if the DMCA allows you something and the CFAA, in the end, the bug bounty terms need to allow you the access, needs to give you the authorized access. So a little bit of proof of concept. I know that you like demos and everything, and if someone in the end wanna, just name a bug bounty terms and a bug bounty program, and then we go and take a look at the terms, I'm up for that. So a little bit of proof of concept. So many programs, they say stuff like this: you agree to comply with all applicable domestic and international laws. I know you are aware of everything, right? You know them by heart. Ordinances, whether these are in the mandate, and regulations regarding your use of our website, okay? I will not say from which platform is this, but yeah. And this is, you see it with, this language of compliance with all laws. You see it in Twitter, you see it in Yahoo, you see it in Google, it's all over the place. Then you have platforms that don't say nothing about laws, okay? Nothing. This is also confusing because they need to provide you with authorized access, right? This is also, it might create a representation for the hunter. There is no legal limitation to what he's doing, okay? And as I mentioned, another problem is this kind of disclosure problem like we have in consumer law. So programs, sponsor companies and platforms, they divide the legal terms from the general, technical scope and, the money you get, everybody reads that. They divide it and they don't put it together. It's also problematic because you don't read it when it's there, but if you put it somewhere else, with the terms of use hyperlink, that's not helpful at all. So we see that, for example, in Uber, and I know that platforms are working on, creating these interfaces where they clearly define the scope for the hackers, but, you need to think about making sure hunters know where they're going and what are the legal risks they're taking. So this is, for example, for Google. of course, your testing must not violate any law. And this will relate to my very important message. If you don't give them authorized access explicitly, if you are subjecting hackers to EULAs, you're not allowing them to comply with the law. The law right now gives the companies and the platforms the tool to facilitate security research, but you cannot just say vaguely, comply with all laws without crafting the disclaimer, the exemption, saying you will not take action against researchers that are in compliance with the scope of the terms, with the disclosure guidelines of the program. So, the most paradoxical example are, terms that create almost a by definition breach. So this is like terms that subject in the bug bounty program the hacker to the general EULA language, so the end user license agreement of the company. So we see that, for example, at AVG, and even, believe it or not, Facebook. Okay, they say that your participation in this program must comply with all guidelines of all their products. So if you go to WhatsApp terms, if you go to literally almost any software company's end user license agreement, you're gonna expect, the legal language saying you should not reverse engineering, you should not copy, you should not, be decompiling and all of this stuff. I'm not a researcher, but I know you need to do this kind of stuff in order to, be successful in the bug bounty program. So this is the most problematic because this creates a by definition legal breach under the DMCA and under the Computer Fraud and Abuse Act. And these are, there are serious civil and criminal liabilities there. So, and I know, we should also think about the legal, the legal risk of the companies, but this is clearly, there is no logic at this. So this is, for example, and I showed you this Alibaba example, which is clearly, please penetrate our system, and we give you money when you give us bugs, but please don't penetrate our system. So I don't get it at all. And this is Facebook, so you can see you do not access or use or copy or adapt or modify or prepare, the legal copyright language we are used to see. So we also have some examples from hackers' platforms. And they, don't get me wrong, I love their work. They're doing important work for hackers, okay? But in this kind of case, they are a very important part of the problem, but also of the proposed solution I will get to. So you see, they say, you need to represent, your report doesn't infringe any, violate any third party's right. But, hackers are doing what they're doing. So they might be infringing copyright laws, okay? And we see, you need to comply with all applicable domestic and international laws. We see this kind of language, okay? I will get to their role in the end, okay? They should be actually the intermediaries that make sure that all of the bug bounty program terms are facilitating safe harbors for research. And they can do that. They can do that in the process of negotiation. I also see this kind of hackers catch-22, okay? Now, this is happening where the most rewarding vulnerabilities are also the one that requires the most legal risk, okay? And together with that, there is no authorizing language. So, for example, take Netgear. Netgear say that unauthorized access to Netgear cloud storage video files for all customers will get you the best, reward. They might give, they might offer, more rewards now. But this is problematic if you're not clarifying the hackers are able to, authorize your systems. Some discussion about exceptions. So, as I mentioned, we have this disparity in terms across different companies. But there are exceptions, and the exceptions are really interesting. Okay, so some programs specifically include language that exempt hackers from liability, noting in the contract, so they take the obligation among themselves, that they will not take any legal action against hackers that comply with the guidelines. So this is Tesla, for example, and the Department of Defense in their very important hack the Pentagon and now hack the Army, and I need to thank Katie Missouri for this. They include some guidelines saying that if you are if you're in compliance with their guidelines, they will not take action against you. And moreover, if someone will initiate, a third party will initiate a case against you, they will help you. They will say, you are part of my program. Now, if governmental organizations with very sensitive system, okay, they allow, after discussing with the Department of Justice, which is who's in charge, for the law, they did it in collaboration with the Department of Justice. They allow themselves to put this kind of language. I do not see any rationale in the world that a private company trying to protect their IP, in account of the legal risk of the hacker, will not do the same. If Tesla can do it, why cannot Facebook? So these are examples of stuff that could be done. And honestly, I think that no one paid attention. So a little bit of more like proof of concept. Why do I say platforms matter? So they have an additional layer of terms, like 20 or 30 more pages for hackers to read. Now, who here read the background of HackerOne 4 to 5 different contracts?
You did.
I did. Yes, thank you. I did. Now, their terms are, they apply in addition to the specific contract. And sometimes there are discrepancies and conflicts. A hacker doesn't know how to solve that. The only thing that is solved is in the case of disclosure. In the case of disclosure, the specific contract, the specific guidelines of the program, they prevail. So this is another issue. And you saw there are also some kind of problems in the platform's terms as well. OK. So this is an example from Background. So their language could be broader than the specific company language. For example, this is regarding who can participate. So they say that people from any country that is subject to US or other country sanctions should not be participating. But usually it's only US in the contracts in the back bounty program. So this is just an example. You can have some kind of discrepancies. Unclear disclosure, I told you that, okay? Microsoft, for example, the legal terms are not in the there is no legal part. It's under the FAQ. And it says legal notice. That wasn't very clear to me, so I don't know how, security people will face that. And I told you about Uber, they have a link to here and that. You need to go all over the place to get the disclosure about the legal terms. So in a nutshell, this is the paradox. It's all over the place. But we do not only speak about problems, right? We want a solution. And the good thing is the law and you are able to be a part of this solution. So I will suggest a number of small changes that might mitigate this legal risk of thousands of hackers participating in bug bounties. First of all, I appreciate what platforms and companies are doing, and I understand they want to cover their asses a little bit. But you can find a common ground, okay? You can find something which is in between, and this is what we see in the DoD terms, okay? And you have a very important role here. You do not need to, agree to this take it or leave it mentality, okay? You can individually unite or through the platform demand to see the language. And the platform can communicate this to the companies. They can offer a template, okay, a standard set of terms that are, kind of representative of the balancing between the hackers and the company's needs. First of all, eliminate all of this paradoxical, do not reverse engineering language. HackerOne, background, do a union that, will, read it or hire a lawyer or I don't know what. Every company that has do not reverse engineer language that subject the hackers in the bug bounty program to the terms of the EULA, they need to delete that. And they can do it now as we speak. This is a very easy solution. We have the privilege of doing, we are in the private ordering space. You don't need to run to Congress. You can, initiate this change right here, demanding this kind of change. It's just a few clicks away. Also, as I mentioned, I think that the platform should have a role here. They should review the terms. all programs should include exempting language from any legal liability and obligation not to prosecute and sue hackers that follow the guidelines. Okay, we talked about the Tesla, the General Motors, the DoD examples. And as I mentioned, HackerOne and Background should demand this from all companies. This emergence of super hunters, which is reported by Background and HackerOne, it suggests that hackers, they operate in 2 to 5 programs. That's it. Okay? They don't have the luxury of reading all the programs and making sure the legal terms are sufficient in terms of mitigating the risks. So this is something that the platforms should make sure. Standardization, this is very important. Okay? We could create a situation where across industries and sponsor, one language is used. And this will also reduce transaction costs. Okay, you will have one language which is agreed, and there are not many disparities. In the end, we do see similarities between the terms. They all want to create this situation where they authorize access to the specific purpose of the, of the program and, in the scope of the program. So this is not something very complicated. They all want to protect their IP. So we can have one specific set of terms, like in Creative Commons, like in open source, right? Like licensing language across platforms, across industries, and also hackers will not need to know everything and and go and read everything, because this will reduce the information burden on hackers. Specific authorization for the purposes of the CFAA and the DMCA. Okay, I said it. Contracts means a lot. In order for you to be exempt on the DMCA and the CFAA, we need a contract to give you authorized access. So for this, for example, I suggest some specific language, which I will share with HackerOne and Background, and they can run it through their lawyers, okay, that will specifically say, it is hereby clarified that researchers that follow these guidelines are granted authorized access for the purposes of the CFAA, DMCA, and any applicable law to test the targeted system solely in a matter and scope defined herein. So you can do it within the scope of the program. And as I mentioned, and this is very powerful, I want companies to commit towards their platform. They will not prosecute hackers. Then if something happens, the platforms can really protect their crowd, okay? Because they have a contractual obligation, right, from the company. So it's not a one-way street where, you agree to do everything and comply with the laws, and then the companies can do whatever they want. So we add another layer of, of commitment, of legal obligation on it. Simplify disclosure. Disclose key legal prohibition, don't use complicated language, and, I can elaborate on that later. Use like you can, you cannot, illustrations, and educate your hackers, the crowd, and the hunters about the legal risks. Not just, I've been to all the webinars. It's lawyers talking with companies. What about lawyers talking with hunters? You need to educate your crowd. And as I mentioned, platform have an important role to play as well, okay? They should be negotiating with the companies. They should change their guidelines to adapt the same exempting language. And in the end, I wanted to conclude, this is just a case study. What I want you to take from this, it's not this legal bug bounty, that too, but this is not very important. What is more important, that we've been talking about these issues for years, but the individual hacker voice is not heard. You need to unite. You need to do collective bargaining. You need to take command and own the legal landscape of this community. Okay, hackers, platforms, and companies, they're doing the best they can, but they need your help. So this is just, don't surrender to this I accept culture. This is just one example of how hackers, united in one front, can advocate for mitigating the risk and ensuring their rights. I see a future where you have a union. I know it sounds crazy, right? Unite. Hackers of, DEF CON, they didn't really like my submission. I'm coming to Sky Talks, and you will have a full hour of this if you're still interested. But there is a lot of power in voting in your feet. This is what we know for consumer law. That if consumers vote in their feet, and they're not going with a company that doesn't give them the rights they want, then the drafter, he changes the terms. we call it term salience. So if you unite, if you pay attention to your legal rights, they're quite important. I mean, maybe not as important, as the technical stuff, but still, you can really get your message out there. So I'm going to finish it up. If you have questions, I'm here. You're welcome to approach me, and I take you for your time. And I hope this kind of rough version of my script was okay. And that's it.